Property Code. Now, we are done with patents, we are done with inventions. Let us move forward to trademarks. Now, a trademark is defined under Section 121.1 of our Intellectual Property Code as any visible sign distinguishing the goods or services of an enterprise. It is a sign or a symbol that sets goods or services apart from all other similar goods or services. It identifies them as having been produced by this particular company, entity, or enterprise. Nakikita nyo naman yung mga trademark symbols or logos dito sa kanan ng inyong screen ngayon. Very iconic. Without identifying or without indicating the names of these companies. Kilala nyo sila. I'm sure. At least most of these companies. No? You can see Sebpac, Cebu Pacific. You can see Togo, Meralco, SM, PLDT, Globe, ABS-CBN even, Land Bank. So trademarks include logos. It includes brand names. It also includes taglines. Kay Meralco, di ba? Ano ang tagline niyan? May liwanag ang buhay. Pag BDO, di ba? We find ways. Pag Super Ferry, sakay na. Pag SM, we got it all for you. Now, the trademark owner has an exclusive right to the exclusion of all others to use, sell, license, and profit from their trademark. Hindi pwedeng kung sino-sino lang ang gagamit ng trademark. Only the owner. Siya lang at wala nang iba. Now, the term of protection of a trademark is 10 years. 10 years lang. But it can be renewed every 10 years. So technically speaking, while relatively maikli ang buhay ng trademark protection, it can always be renewed. So remember that, 10 years and can be renewed every 10 years. So we can say na may forever din naman sa trademarks. Though syempre, it entails some degree of diligence on the part of the trademark owner. Kailangan masipag sila sa pag-renew in order for them to exercise continued exclusive rights over that trademark. So, a trademark, a mark can be a word, a single word, it can be a phrase, it can be a symbol, or it can be a combination of these other things. Kagaya naman ng nakita ninyo kanina at yung nakikita ninyo ngayon. You see, dito sa left-hand corner ng inyong screen, you see this logo. Without any accompanying text, you know, no? Kung kaninong logo ito. You know which app, you know which company this identifies. I need not speak of it. And you will still know regardless. Now, how does one acquire ownership of a trademark? Paano magiging entitled ng isang trademark owner dun sa protection or protections extended by the Intellectual Property Code? Section 122 of the law tells us that as a general rule, to acquire rights in a mark, registration is required. Sa madaling sabi, para ang trademark ay maipaglaban, registration ay kailangan. But that's the general rule. There are exceptional, super exceptional circumstances where registration can come later. Though of course, ideally, dapat registration pa rin. Kailangan makapagparehistro pa rin in order for a trademark owner to be entitled to the full range of protective measures imposed by the law. But there's this thing about well-known marks na kahit na hindi pa sila rehistrado, solely on the basis of kilalang kilala kasi ito, alam ng lahat or alam ng nakararami na itong logo na to, itong symbol na to, itong word or phrase na to, this pertains to only one thing. This pertains to only one product. This pertains to only one website. And if a mark is well known, even without registration, they are still entitled to protection. Like for example, the Facebook logo, kaya nandiyan dyan sa screen. The Facebook logo was considered by the Intellectual Property Office of the Philippines, or IPOPHIL, as a well-known mark. In its decision, yes, the IPO promulgates decisions regarding the interpretation and application of intellectual property law. In the case of Facebook Inc. versus Lina Petalver Celino, Decision number 2010-62, promulgated July 29, 2010. Imagine, as early as 2010, nagfa-Farmville pa lang yata ang mga tao nito. Uso pa yata ang mafia wars nito. Meron pa yata tayong post-Friendster hangover nito. But nevertheless, Facebook has gained such a substantial user base in the Philippines this early on. So much so that the Facebook logo at the time, hindi pa itong bilog na to, I think it's a square logo pa with a darker shade of blue. That logo was already considered a well-known mark. The implication there is that they are such rabid consumers of social media that even before Facebook gained such a massive influence, I would think, over Filipino lives, noong time na Facebook was merely used as a means to play some casual games, to connect with friends, hindi pa natin ginagamit si Facebook para ma-apprise tayo sa mga balita. Facebook was already well-known. And its logo already constituted a well-known mark. Though of course, later on, I would think Facebook has already filed the necessary registration sa IPOPHIL ngayon. Kasi, well, there is already a Facebook Philippines now. They have a branch office here. And I'm pretty sure, all of the paperwork, lahat yan settled na. But then again, this is already 2022. Malayong-malayo na sa 2010. But you get the idea. As a general rule, let's recap. No? As a general rule, para ang mark ay maprotektahan, registration ay kailangan. By way of exception, well-known marks, kahit na hindi pa sila registered, they are also protected. They are entitled to protection even without registration. Now, which marks are non-registrable? Hindi pa pwedeng iparehistro sa IPOPHIL. Marks that are immoral, deceptive, scandalous, or disparaging. Hindi ko na kailangang magbigay ng example, no? Kaya nyo na to. Next, flags, coat of arms, and other emblems. You can't file a trademark application over the Philippine flag. I mean, come on. Names, portraits, or signatures identifying a particular individual. Like for example, no? Jim Carrey. Just the name Jim Carrey. You can't apply for a trademark over that name. At ganun din, no? Names, portraits, or signatures of a deceased president of the Philippines. So, Carlos P. Garcia or Elpidio Quirino, mag-apply ako ng trademark for those. Hindi yun pwede. Non-registrable. Marks that are misleading. Mamaya, no? We will be talking about McDonald's. Merong mga establishments out there, even now, na ang pangalan nila ay halos kapareha ng pangalang McDonald's. Now, of course, people we are discerning, no? We can exercise discretion. We know the difference. We know what McDo is. Alam din naman natin yung mga resto na gaya-gaya, but not quite McDo. Not even close, baby. But nevertheless, an argument can still be put forward, especially by McDo, that these businesses, these entities, make use of marks, trademarks that are misleading. Sounds dangerously close to McDo or McDonald's. So if the mark is misleading, it cannot be registered. Of course, another species of non-registrable marks ay yung generic. No? Generic. So, sabon. Or the word shampoo. That's too generic. You have to add more spice to it in order to set your product apart from all others. Hindi mo pwedeng i-trademark yung generic term applying to this particular class of things. So no matter how hard you try, you would not be able to register the word sabon. That's too generic. Descriptive words as well cannot be registered. Though of course, by way of exception, the term or terms, when they have already acquired distinctiveness or yung tinatawag nating secondary meaning, if a word, an otherwise descriptive word, has acquired secondary meaning, it can be registered as a brand name, not as a merely descriptive term. The primary example here that should come to mind is the word sharp. Diba? The word sharp is an adjective. But nevertheless, the word has acquired secondary meaning with reference to particular electronic devices associated with the company or produced by the company, which of course would lead to valid registration. Kasi when you hear sharp, ang primary meaning niya is of course matalas. But after years and years of company existence, corporate existence, and years of producing quality electronic devices, the word sharp has acquired secondary meaning. Gawang sharp, gawa ng kumpanyang to. So this class is the doctrine of secondary meaning as an exception to the rule that merely descriptive terms cannot be registered. Of course, words that are customary to trade cannot be registered as well. Like for example, no, the word check or the Filipino word loan word cheque. You can't register that. That term is customary to commerce. Diba? Imagine. O kaya ipaparegister mo as a mark legal tender. You can't do that. Ito yung sinasabi ko about McDo, no? You cannot register a mark that is identical or confusingly similar with an internationally well-known mark. I am referring to the case of McDonald's Corporation versus McJoy Fast Food Corporation. Decided by the Supreme Court in 2007, GR number 166115. So McJoy is a restaurant in Cebu City, I think. Now, there was a time na nagfa-file ng iba't ibang mga kaso left and right si McDonald's protecting its IP rights, primarily over its trademark, over its name. Kasi there are many restaurants which uses names that are confusingly similar to McDonald's. Though of course, one could proffer the argument na ang layo naman po ng McJoy sa McDo. But then again, it's McDonald's prerogative in the protection or in the defense of its trade name. All right? The Supreme Court ruled in favor of McDonald's, long story short. And McJoy, parang kinain siya ng lupa. I've been trying to look for a business establishment na ganito ang pangalan sa Cebu, online, or that one time na pumunta ako doon, couldn't see it. Parang nabura sila from the face of the earth. Though then again, I'm not from Cebu. Dayo lang ako, I wouldn't know. But yun nga, kagaya nga ng sinabi ko ngayon, there are some restaurants, smaller restaurants at that, na ang pangalan ay halos kapareho din ng McDonald's. Though ngayon, it would appear na hindi na ganun kamasugid si McDo in, enforcing its right over its trademark or trademarks. Perhaps, though of course we can only presume, perhaps that is because consumers are wiser nowadays. Kahit na halos kapareho yan ng pangalang McDonald's, kahit na katunog yan ng McDo, we know better, don't we? And of course, marks that are contrary to public order and morality also cannot be registered. So we're done with two. We're done with patents and inventions. We are done with trademarks. Now let us move forward to copyright. Copyright is the legal protection extended to the owner of the rights in an original work. An original work, on the other hand, refers to intellectual creation in the literary, scientific, and artistic domain. Gaya nga ng sinabi ko kanina, you write a song, you come up with a painting, you draw something, you write a story, a poem, a novel, copyrightable. If it's an original work of whatever nature, whether it's literary, scientific, or artistic, as long as it's original, you have copyright over it. You have a right over your work. Now, of course, this is without prejudice to what we call derivative works that we will be talking about in a bit. So what creations are covered by copyright protection? These things: books and other writings, musical works, so this pertains to songs, musicals, and other similar things, films, of course, and photographic works, ornamental designs or models of manufacture, paintings, sculptures, other works of art, computer programs, and even mobile apps, and other similar products, other similar creations. Now, the law grants authors, artists, and other creators automatic protection. Kagaya nga ng sinabi ko kanina, from the moment of creation. The moment you are finished creating this literary masterpiece, the moment you finish writing your poem, the moment you finish your painting, the moment you finish writing that song, you already have copyright, you already hold copyright over it. And considering that copyright arises from the moment of creation, registration is not necessary per se. You need not register it with the IPOFIL. However, in order for you to better enforce your copyright over this intellectual creation, you may opt to file for copyright registration with IPOFIL. And then IPOFIL, after studying your application, they will issue you a certificate of copyright registration. So what does the certificate state? Nakalagay doon na ikaw ang author, ang artist, ang creator behind this particular intellectual creation. This book, this poem, this song, this musical, this artwork, this mobile app. And you created it in a particular date, and that copyright has arisen from the moment You created this thing. Now, what is the extent of the protection accorded by copyright? Copyright grants you a slew of rights. Actually, dalawa lang, no? In general. The copyright owner is granted economic rights and moral rights over the thing. So when we speak of economic rights, we refer to the rights of the author or copyright owner to derive financial reward from the use of his works by others. For example, did you know that every time you hear a particular song being used in a telenovela, in a TV series, bawat beses na patutugtugin yan, may royalties na napupunta doon sa manunugtog, doon sa musikero, doon sa kompositor. For example, no? Yung telenovela ni na Enrique Hill at Liza Soberano, I think it's Make It With You, yung hindi natapos dahil sa COVID. Every time na patugtugin yung theme song, yung Make It With You as covered by Ben and Ben, Ben and Ben receives royalties or received royalties every time na patugtugin yun. Or a better example would be, I think, yung Ang Probinsyano. Every time na patugtugin dati yung Huwag Ka Nang Umiyak, kung wala ka nang maintindihan, kung wala ka nang malalapitan, kapit ka sa akin, hindi kita bibitawan. Every time na patutugtugin yan, na naka-zoom in yung camera sa mga mukha ni Cardo Dalisay. Every single time, may royalties na nakukuha si Gary V. Dahil siya yung kumanta. And then may royalties din rather na nakukuha si Ebe Dancel. Kasi siya yung nag-compose, siya yung nagsulat nung kanta. Ngayon, you might be thinking, bakit dalawa silang nakakakuha? We will be discussing that shortly with regard to derivative works. Now, so malinaw naman yung economic rights. Kaya ang lakas-lakas ng kita ng Silent Sanctuary kahit na wala silang mga gigs, especially nitong pandemic, no? Sino bang may gigs, by the way? Wala naman, maliban dun sa mga online events, no? Kasi, well, Silent Sanctuary, for example, as well as I think December Avenue, yung ganyang janrahan ng mga senti, sila yung madalas na natatap para kumanta sa mga telenovela kasi alam nila kung paano magpakirot ng puso ng mga nakikinig. Bawat beses na patugtugin yung mga kanta nila as theme song, whether dun sa mismong telenovela or even sa mga commercials, they get royalties. Every time. Every single time. So yan ang economic rights. How about moral rights though? Moral rights refer to the rights of the author to claim authorship of the work. Yun yung tinatawag nating right of paternity. Moral rights also entail the right to restrain the use of the author's name para sa kanyang literary work. Okay? So, for example, somebody makes use of the content produced by an author without any attribution. Nakita ni author yung, for example, a YouTube video, basically making use of his research na ipinalabas niya sa kanyang libro in the form of a novel. No? For example, parang mala Da Vinci Code na nobela. So yung mga conspiracy theories na sinulat niya doon sa kanyang novel, ginamit nung content creator sa YouTube without any attribution. Hindi sinabi na actually base ito sa libro ni ganito, sa kanyang nobela. Walang ganon. No attribution whatsoever. By way of moral right, itong si copyright owner, pwede niyang i-insist na i-attribute mo na actually sa novel ko galing yung pinagsasasabi ni content creator sa kanyang video. And I demand that attribution be done or be made accordingly. I-shout out mo naman ako sa video mo kasi sa akin galing yung content. So yan ang moral rights. So applying yung twin rights ng isang copyright holder, the effect would be that the copyright holder can authorize or prohibit the reproduction of a work in all forms, public performance and communication of the work to the public, broadcasting, translation into other languages, and adaptation. Yung from novel format to a film, or from a film or screenplay to novel format. For example, mapapansin niyo, there are some bestseller novels na mayroong bagong edition, na nagsimula siya as softbound, nag-bestselling, then mayroong bagong edition ng libro, hardbound naman, hardcover rather. There are some adaptations of a work, like for example, Huling El Bimbo, the song by Eraserheads. Somebody came up with a musical, based on ang Huling El Bimbo and other Eraserheads songs. Of course, may basbas yan ng members ng Eraserheads because that is their prerogative as copyright holders. So that's Eli Buendia and Company. The song Anak by Freddie Aguilar was translated into many, many different languages. Of course, dahil pinayagan sila ni Ka Freddy. Merong novels like, for example, American Gods by Neil Gaiman. Initially, nobela yan. It was a book na ginawa ng TV series adaptation. Or more recently, if you're a fan of Neil Gaiman, you know the Sandman comics. Meron siyang Netflix adaptation. Upcoming, I think. Hindi pa yata nag-uumpisa. And of course, Game of Thrones, A Song of Ice and Fire by George R.R. Martin. From a novel series na hanggang ngayon ay hindi pa tapos kasi mabagal si GRRM magsulat. Ginawa siyang TV series na natapos na. Lackluster ending, by the way. Lord of the Rings, a novel trilogy. Ginawang film. Harry Potter, Twilight. Inversely, like for example, Bleach, the manga, ginawang TV series na itutuloy na this year, I think. There were some movies na expounding on the main universe of Bleach na ginawa ng novel adaptation. Na hanggang ngayon ay hindi ko pa rin tapos basahin. I bought, I think, 3 novels yun. Hindi ko pa tapos yung book 1. But you get the idea. Malawak ang coverage ng karapatan ng isang copyright holder. Pwede niyang pahintulutan o ipagbawal ang reproduction ng kanyang gawa, public performances o broadcasting ng kanyang gawa. Pwede niyang pahintulutan o ipagbawal ang pag-translate ng kanyang gawa into different languages. Pwede niyang pahintulutan o ipagbawal ang pag-adapt ng kanyang gawa from one form of media or from one medium to another. Now, one of the more pressing questions, madalas to sa social media, you can see posts, ang haba-haba. You would think na, napaka-erudite, ano bang tawag dito? Napaka-eloquent naman itong poster na to. Parang hindi normal, hindi naman siya ganito ka matatas. Ang very well argued, though I might not necessarily be in agreement with what he says. Parang napaka-spirited ng kanyang pagkaka-explain sa kanyang post. Tapos makikita ninyo sa dulo, CTTO. Hindi mo pala yan original post. So ibig sabihin, you're just parroting the ideas of other people. Oh, di ba? But you see, people are under the impression that it's okay to copy-paste works, no? Or posts or content produced and released by other people without even attributing the author properly. Mapapansin nyo yan, wala naman, minsan walang nakalagay kung sino yung original post or original poster rather. O kung sino yung talagang original na nagsulat. Meron lang nakalagay na CTTO, credits to the owner or credit to the owner. And people are thinking that it's sufficient already. Na-credit ko naman, may CTTO naman. Is it enough? Actually, the answer is no. Because kagaya nga ng napag-usapan natin kanina, this time basing on Section 193.1 of our Intellectual Property Code, bahagi ng moral rights, yung attribution, proper attribution. Gawang likhayan ng ibang tao, you attribute the person, you attribute the creator or the author. The author has the right to require that the authorship of the works be attributed to him. That his name, as far as practicable, be indicated in a prominent way. Have the decency to attribute the post sa kung sino man yung original poster. And remember, hindi pa pwedeng gawing counter-argument dyan yung hindi naman niya pina-register yung kanyang copyright sa Intellectual Property Office. Therefore, free for all yan. Pwede kong i-repost without proper attribution besides my CTTO naman. No. Remember, kagaya nga ng sinabi ko kanina, registration is desired but not really necessary because a copyright arises from the moment of creation